Yeah, we're going to get right to the speaker tonight. Well, it's Chris Albert, DSA member, who has put together a program for us this evening concerning U.S. copyright laws and how it relates to songwriters and songwriting. Apparently, there's some new things that are going on in that part of the world, and I'm sure we can all learn something new to help us keep our works, in the public domain somehow or another, so we can copyright our music and.
You're going to keep it in the public domain or out of it?
Oh well,
Yeah.
I don't know, but if you're fortunate enough to have a hit, then you'll be glad you got it copyrighted. So, and Chris is a longtime singer, songwriter, music producer, performer. He kind of has been doing it all for the last 40 years, so he knows a thing or two about what's going on with copyright and all kinds of things about the music industry. So we might pick his brain on various things if we have time or anybody has a question. But I'm going to turn it over to Chris, and he's going to kind of get us going, I guess. All right, take it away, Chris.
Okay, doke. Well, welcome everybody. I'm glad to have you all join in on this. I've been working with the U.S. Copyright Office in helping them go through their new platform that they're doing so you can register your copyright. They've made it real easy, very easy to work with. They've combined some things, take some things. But I'm going to introduce Trey Robertson and Miriam Lord. They work for the U.S. Copyright Office, and they're the ones behind this thing. And they're going to give you a little presentation and show you what's new and what's up and coming. And what I like about them, they're very fine people to talk to. They'll answer any question, and they are very cooperative. And with today's AI and all this is probably the most important thing for any songwriter, poet, or anybody that's doing anything out there. Take it away, Miriam.
Thank you. Thank you so much, Chris, and thank you so much to the Dell Songwriters for having the U.S. Copyright Office today. It's a real pleasure to be here with all of you. I myself was actually just not in Dallas, but in the Texas area for South by earlier this spring, talking about the copyright, talking about what we do, talking about how to make what we have as accessible as possible for all of you. So it's a real pleasure to be able to be pulled in. I wanted to thank Chris for what he just mentioned, which is to be involved with some of the work the office is doing to prepare the next generation of our online copyright registration system. This is part of an overall update to systems as government offices do from time to time, and having that input from people who are using these systems is really, really important. So that's a really important through line between Chris's work with us and also what we're doing today. And then we can talk a little bit about all the things on the margins of that today and all the resources. So what I want to leave you with before we get into some slides, and then we'll be available for some Q&A, it's just that we're around. We are here for you. In the background of our Zooms today, you can see our exhibit in the Copyright Office. This is on the Capitol campus in Washington, D.C., on the 4th floor of the Madison building in the U.S. Copyright Office within the Library of Congress. We have an exhibit called Find Yourself a Copyright. Takes you through music and other related works, just to understand what you already own, what registration is, how the law has developed, and how important it is and central it is to the way this country works and the importance of all the work that all of you do. So with thanks to Trey, who's joining me today from the registration department of the Copyright Office. I'm Miriam Lord. I am an Associate Registrar of Copyrights, so a member of the leadership team of the office, and I'm over public information and education. So what that means is it's part of my job to talk to all of you. I run a whole team of folks who do this from the Public Information Office, where if you call the Copyright Office, that's who you talk to first, to communications and press, to producing things like exhibits and materials and the website and YouTube videos, conferences, ways to connect with the outside world. So if you have any questions about copyright or you have any questions about the Copyright Office, chances are good that I'm going to see it at some point. And so it's a pleasure to just look you in the eye and tell you that that we're here for you. I'm actually not from Texas, but I'm from Colorado, so I know what it is like in that, you know, out west with the big skies, and I send my best to you. So I'll be sharing my screen. I'll talk for a little while. Then I'll step back and let Trey Robinson, who's in our registration department, talk a little bit about the specifics of registration for musicians. And we'll give a little bit of an overview about other hot topics in the office so that you can be in the know. And then we'll point you to some resources, and then we'll take some questions. And then I'll just repeat, happy to give you these slides. We'll send them to Chris afterwards. He can distribute them to you so you can see them later. So don't worry about taking notes. It's fine. We'll always be here. You could just call the copyright office at the line that's on the website. The question will get to the right place. So sit back, relax. We're gonna take you on just a little drink. All right. Okay. I'm Miriam Lord. This is Trey Robinson, and we're going to get started today from the U.S. Copyright Office at the Library of Congress. Just a couple words about who we are. The United States Copyright Office goes back to a founding in 1870. Prior to that time, all copyright registrations happened in district courts all around the country until they were all overwhelmed with maps, books, other registered works of visual art. And Congress decided it was time to put an end to the madness, centralize this all in the federal government. So the Copyright Office was set up as a function of the Library of Congress at that time, and then several years later became a separate department. So we are the U.S. agency charged with administering the Copyright Act, which is derived from the U.S. Constitution. On the slide here is a picture of our Madison building, which is where Trey and I both have offices. We administer the copyright law, which includes making and maintaining public records, advising Congress, dealing with regulations, doing international work, and of course, providing information to the public. So you can see some of our folks out there doing some outreach just like we are today. Here's who we are. I'm there in the middle. The Register of Copyrights, Shira Perlmutter. She's the head of the U.S. Copyright Office, and she reports up through the Librarian of Congress into Congress. And here is the rest of the leadership. So Trey's boss is Rob Kasnick, who's head of policy and practice there. All right, we're going to dive right in. I'm going to just talk, as I'm an IP lawyer, I'm going to talk a little bit about just intellectual property and how it all fits together. We know that there's a wide range of expertise on the call. You guys really know your business, which is music, and a lot of you have a lot of expertise in copyright already. But just bear with us while we give you the basics and then get into the good stuff. So intellectual property, or IP, goes back and is based in the Constitution. Patents and copyrights specifically tie back to a clause that's in the Constitution. It's one of the first individual rights before even the Bill of Rights existed, about securing for authors and inventors for a limited time the exclusive rights in their writings and inventions. That's really the basis of what I like to talk about is how you get paid. Before coming into the government, I ran the Volunteer Lawyers for the Arts in Philadelphia, which is very similar to the Texas Accountants and Lawyers for the Arts in the Texas area. So I've worked with people who have to think about what this means for them, how they fit it into their lives. And today we'll be talking about some of that. So trademarks identify the source of goods or services. This is your brand name. This could be your band name. This can be your tagline, but it isn't your music. Patents protect new processes and inventions. This is going to protect maybe a new musical instrument that you invent. It could protect, in other walks of life, a chemical innovation or mechanical innovation. It's for inventors. It protects the utility of something or how it works. But copyright protects creative expression fixed in a tangible medium. So it protects art, it protects things that come from the mind and become an expression. And with that, I'm going to turn it over to Trey to talk just a little bit about copyright law.
Thank you so much, Miriam. I just want to say it's a great honor to be able to talk to you all about copyright. I knew I was in good company. I'm also a musician. Um, Actually, I have an undergraduate degree in music from Middle Tennessee State University, originally from Memphis, Tennessee, and then a master's degree from University of Miami. So I knew I was in good company um, when I knew that this was the audience. So happy to be here and happy to share some information with you all. Um, so copyright law, copyright law is found in Title 17 of the U.S. Code. It's also known as the Copyright Act. The law states that copyright protects original works of authorships that are fixed in a tangible medium of expression. And what that really means is that we first must have a work of authorship, in your case, a song, and that work must be fixed and original in order to be protected by copyright. We'll go over some of the works of authorship categories in more detail, but I'm going to just take a quick moment here to explain what fixed and original mean in this context. And fixed basically means that the expression must be written, recorded, or otherwise captured in a copy that must be sufficiently permanent or stable to be perceived, reproduced, or communicated for more than a transitory duration. The moment a work is fixed is the moment that copyright protection begins. Originality in copyright involves primarily two components. The first is the independent creation, and the second is sufficient creativity. With independent creation, that just means that the work must be independently created by the author, and the work must originate from the author and cannot be copied from another work. In theory, two works can be the same or be similar, and each be the subject to copyright protection, so long as the similarities are simply by chance and not a result of intentional copy. Sufficient creativity requires that the work contain at least a small amount of creative expression, but that small amount must be more than trivial. For example, short musical passages typically do not have enough creative expression to be protected by copyright. Though there's some exceptions to that rule, like there's small sound bits that we've extended copyright to, but I won't get into the nitty gritty of that. Next slide, please. So I touched a little bit on works of authorship. These categories are typically literary works. We have a literary division at the Copyright Office that primarily deals with books, newspapers, serials, periodicals. The one that most relevant to this audience is musical works and any accompanying lyrics. There are also dramatic works, pantomimes and choreographic works, pictorial, graphic and sculptural works are part of our visual arts division. And then we have motion pictures and other audio visual works. That's an extension of the division that I work for, which is the performing arts division. And that division, like I said, includes musical works and also sound recordings. And architectural works are also considered original works of authorship. Next slide, please. So copyright in music, down to the nucleus of this conversation. Music, by definition, when it comes to registration, when it comes to copyright, music is a succession of pitches or rhythms, or both, usually in some definite pattern. You all probably know that very clearly. But to be copyrightable, a musical work must originate from a human being. And that's kind of, it seems basic, but nowadays with AI and algorithms, it cannot go unsaid. Music generated solely from an algorithm, an AI algorithm, is not copyrightable. More than a mere transposition, changing one key to another, is not copyrightable typically. And music also, to be copyrightable, has to be more than just the output of a generative AI system. That's important because as days go by, more and more people are using artificial intelligence platforms to create their works. And just basic sort of kind of prompts that produce AI generated material would not be found to be copyrightable. I won't get into that, but there's a lot of sort of kind of parameters and nuances that are part of that consideration and copyrightability. Next slide, please. Copyright in songs. A musical work, like I said before, is often also used, musical work and song are interchangeable terms, but specifically they mean that's the underlying composition, the underlying musical composition, along with any accompanying lyrics. And a sound recording is a series of musical, spoken, or other sounds that are fixed in a recording medium, such as a CD, a vinyl, a digital file. Digital files are probably the most common ways that we receive works nowadays. M4A files, MP3 files, but those are typically called a phonorecord. There's a difference between sound recording and musical work that we often have to explain with our applicants. But just keep in mind that musical work is the song, the underlying composition, and the sound recording is the fixation. Next slide, please. All right. Now, copyright in songs, when we talk more about musical works, the author is commonly considered the person who composes, the person who writes the lyrics, or songwriter. So songwriter can be the lyrics, can be the music, can be both. But typically copyright owners may make and distribute copies. They may also make derivative works such as remixes or video versions, and they can publicly perform or display it. Next slide. As stated before, sound recordings are the fixation, but the author of a sound recording is commonly the performer, the singer, somebody who, a rapper, the person who plays the guitar, or the producer or sound engineer, the person that's working the dials, that's at the soundboard. Copyright owners may make and distribute copies and make derivative works. Also, it's important to mention that a public performance is limited to digital audio transmission. So it's like going into your favorite cafe or coffee shop and you're hearing music piped through the speakers. That's considered a public performance. Next slide. Okay, now we get into the nuts and bolts of copyright registration, which is my area of expertise, and I'm always very excited to talk about registration to creatives. But the registration basics here, you should keep in mind that registration is voluntary. It's not mandatory. But when you register your work, it does provide significant benefits. And some of those benefits include it creates a public record of creativity. It establishes a notice to potential licensees, and it provides access to federal courts or the CCB, the Copyright Claims Board. Next slide. Now, the requirements for registration all consist of A, an application form, B, a non-refundable fee, C, the deposit of the work, or a copy of the work, and that's musical works. It can be a sheet music or MP3, like I stated before, or it can be as simple as submitting a PDF of the lyrics or a Word file of the lyrics. For sound recordings, it's typically the MP3, M4A, a CD, LP, etc. Next slide, please. Timing of registration is very important because a lot of people are concerned about any sort of kind of delays in registration. And you should be comforted in the fact that the average processing time when you submit an online application with no correspondence is 6 weeks. And that's pretty, I remember, that's so super efficient. And thankfully we get all kind of compliments from creators saying that, wow, that was fast. I'm happy that I can get my registration application approved and examined in such a timely fashion now. So we're really proud that timing of registration does not take a long time. Next slide, please. How much does it cost? So it's important to mention here that the cost of registration vary. The lowest cost option is $45 for what we refer to as a single application. One work by one individual, $45. But there's also a varying cost for group options that range from $55 up to $95. Next slide. Okay, registering a sound recording and an underlying musical work. It's important to keep in mind that you can register both a sound recording and a musical work if the musical work and sound recording are embodied in the same copy or the same recording file, and if the copyright owner owns both the musical composition and the sound recording. Remember, the sound recording is fixed in an MP3, the musical composition is the actual song. Next slide, please. We do have also the option to register a group of works. The group application options for musicians are as follows. We have the group registration for works on an album of music, which we affectionately call GRAM. Option 1 are with Graham musical works on an album. Option 2, you can also do sound recordings on an album, and if you can include any sort of associated liner notes, photographs, and artwork. All works must be published on the same album, and there are also other eligibility requirements as well to consider. Next slide, please. Oh, you know what, Miriam, could you go to the previous slide? I wanted to point out a couple more options. Sorry about that.
Sure.
So there's the GRAM option. That's the one I just discussed. There's also a group registration for unpublished works, which we refer to as the GRU application. And essentially that's up to 10 works that are unpublished. That we can provide more information for you on the GRU application as well. And then we have the regular standard application that you can also register. Okay, awesome. Next slide.
Thank you. Absolutely. And yes, we have actually, I'm going to get into this in just a minute, but we typically pass out, and I have this just in front of me here, but we have like a card that we will drop you a URL for. But we have a part of the website that's just copyright.gov/ resources that are under our Engage page, which you can find on the front page. Everything for music is there. So we'll drop that into the follow-on that we send out to you guys. That's where you can find videos about all of this. It's where you can find all of the applications that Trey mentioned. It's where you can find explainers, more resources, and things about changes to the law, which I'm about to get into now. I will mention before I get into that we have some great materials in general around how people get paid. And I can't stress enough how much we understand that is important. So it's a complicated area, music and copyright, and so we do our very best to demystify it for you there. Okay. One of the things that's changed over the last 10 years or so in copyright law is the Music Modernization Act. And this is something that some of those materials really point to. So I'm not going to go into detail about it today because we'd be here all evening. And you all have very important things to do in terms of song critiques. We want to leave you to that. But please do come and visit that page and understand a little bit about it, because this is how songwriters get paid for streaming music. This is a change to the law that recognizes that the way that the music business works has changed. And I'll tell you, copyright law, I mean, you started with the Constitution, which relates back to British law, which relates back to the Statute of Anne, which has to do with the printing press. This is an old area of law. And over time, We had the Constitution, we had the Copyright Act in the 1700s, additional copyright acts later on in the 1800s. There's the 1909 Act, then there's the 1976 Act that really brought us into the current era where you own it as soon as you fix it, as soon as you make it. You don't have to register it anymore, although it comes with some benefits. And the internet brought about the digital music copyright, the DMCA, the Digital Millennium Copyright Act that has to do with things like notice and takedown that happened in the late 90s and early 2000s. And then we waited, and then the Music Modernization and the CASE Act came along. And so that's where we are right now. We're in this moment where there's been a couple changes to the law. And so the effect for you is that there's been some changes that are intended, for the most part, for people in your position as songwriters to get paid and know how to enforce your rights. So I'm going to talk a little bit about both of those things now. Music Modernization Act, like I said, it has to do with streaming for music, and there's resources about how to register at the MLC and get paid and understand what all of your rights are on the website. Second area is the Copyright Claims Board. So back in the winter of 2020, when absolutely nothing else was going on in the news, Congress popped into the law a new function of the Copyright Office and the copyright law, which was a small claims court. So this is a lot like a small claims court that you'd have in your municipal court system, where you bring in small level claims to sort them out. Maybe you settle, maybe you enforce it for a certain amount of money. But this is at the federal level, and it's for copyright only. So we were given a timeline to launch this, and we opened it on time in 2022. So about 3 years ago, in June of 2022. Copyright Claims Board is voluntary. It is all virtual, and it is for copyright. It's designed to be a low barrier to entry, faster, easier way, cheaper way to come to a resolution about a copyright infringement, copyright non-infringement, or a misrepresentation under the DMCA kind of takedown issue. So not for your patent claims, not for trademark claims, not for design claims, not for contract claims, not for estate planning claims, just for copyright claims. It's within the Copyright Office in DC, but no one has to leave their house. You can just file it online. This is something that through the last 3 years we've been observing. It seems to be going well, but we have an open period for comment that actually closes tomorrow. And there'll be a reply period until June. So we want to hear back from people, because according to the CASE Act, which is the statutory piece that developed this, we are going to be issuing a report to Congress in February of next year, evaluating how it's going. So far, we have about 1,200 claims that have been filed in those 3 years. And final determinations are rolling out that handle those kinds of issues. We're seeing a lot of visual art handled in the CCB, but some musical and film works as well. This is definitely an option. And something to know is that when you go into the CCB, this is something that you need to use to bring actions against United States respondents. You still have to go through all of the due process that's required, so service of process, and then time to respond and all of those things. But it's designed to be very friendly. You can always call, get assistance. If you file something and it doesn't quite have what it needs, you can talk it through with one of the clerks in the office, and you can represent yourself. You can certainly get a lawyer. Lawyers can be very helpful, but most of the claimants and respondents are pro se, which is on your own. It's also normal to work with a law school clinic or a pro bono organization to get advice about if this is even for you. But the limit on damages is $30,000. And so if it's under that you're looking for, this is a really good alternative to federal court. You don't have to have registered your work when you file one of these. That's a difference from federal court. If you go to federal court, you have to have already registered your work. And you have more rights the earlier you register it. So within the first 3 months of fixing or publishing your work, you have the best and strongest case in federal court. You have the strongest statutory damages. You have the most likelihood of the other side paying your legal bills, et cetera. It can be very expensive. But CCB is designed to just be a solution to fill some gaps in terms of access to the justice system for creators who are just trying to sort out issues as they arise. So this is something new. Please check it out and let us know if you have any questions. Happy to take those. One thing that had come up when we established the CCB and Congress established it was this is voluntary. Why would anybody agree to be sued here? Aren't they just all going to opt out and say, come sue me in federal court? But what we are finding is that that's really only happening in about 29% of matters because there's incentives for both sides. You know, you limit your liability as a company or an organization being sued, and as somebody who's bringing a case here, you can get more quickly to a resolution. So it's always good. I always say as a lawyer, it's always good to know your rights. It's always good to know how to enforce those rights and to know what all of your options are. And now you have a new one. One of the things that we're hearing from the World IP Organization in Geneva, which is the UN agency over IP, as well as from other countries and their copyright systems, is they're also interested in this kind of concept because everybody has musicians, everybody has artists and authors who are trying to figure out the best way to run their career and understand what's theirs. So we do some of that engagement and explain what we've learned, how our laws work. I'm going to talk a little bit about office resources, but before I do, I just want to acknowledge something that Trey said earlier, which is about intellectual property and copyright and artificial intelligence. The office, as a part of its statutory mandate, does weigh in on copyright law and policy. We provide impartial expertise to both all parties of Congress, both houses of Congress as a subject matter expert, and also to the executive branch and to the judiciary branch as well. And in that role, we issue all kinds of studies and conduct a lot of research about intellectual property, about copyright. So we do have an active study right now on AI and copyright, which is of a lot of interest to people. So if that is of interest to you, we're not going to get into depth about it today, but we can direct you to a lot of those resources, including some registration guidance about how to register works if you're using AI as a tool, which is totally fine. We just have a procedure for you to follow that's clear and online. And just about, in general, issues like digital replicas, issues like copyrightability of works created using generative AI, and about issues we're anticipating putting out the part of the report very soon that's about fair use and any liability or licensing and whether the training of AI is okay in copyright terms. So there's all kinds of issues. It's just like a whole pile of issues. We really embarked on this a couple of years ago because we were starting to get those applications that were coming in, and this is clearly really important to dig into. So we begin to conduct a very broad public outreach, heard from a lot of people, had a lot of listening sessions, did a lot of very, regulatory, transparent comment periods, and are now issuing reports on those. So just keep your eye out for all of that. I think it'll be really interesting. And we're always happy to come back when all of that is out and talk to you about it again. All right. So here's some resources, and actually, Trey, I'm going to hand it back to you to talk a little bit about this. I'm happy to fill in the gaps.
Thank you. The PIO is what we refer to as the Public Information Office. They provide services to all of the creative communities that we serve, and they are open. They do accommodate phone calls, walkthroughs, only by appointment, and you can request access from our website, copyright.gov. You must set up ECO, that's our electronic system, an ECO account prior to your appointment. And you can see the phone numbers there, the contact numbers there, the Washington, D.C. local area number of 202-707-3000, and then the toll-free number 877-476-0778. Next slide, please. I have to sort of kind of give credit where credit is due. The squad that Miriam manages and is over has provided helped to provide some wonderful resources. I can't tell you how many of my music industry friends and colleagues, and how many of my friends that work in sync and place songs and sound recordings for different film, television, streaming outlets. They talk all about the resources that the Copyright Office has and have provided for the creative community. So we have a variety of resources, including YouTube videos, circulars, the copyright public record system, just so many different resources to help people know how to register their works and get additional information about copyright related items. You may also want to refer to our events page, which now has different recordings of office webinars, maybe even some information on artificial intelligence, different series that you can sort of kind of access that provide some copyright essential resources and maybe some musician specific resources as well. So definitely check those things out. YouTube, I call it YouTube University because it's such a great resource to learn anything, and copyright is no exception. So great resources that we have for the people that we serve. Next slide, please.
Thanks, Trey. And I did not plant that, so I appreciate the praise. We'll pass that on to the staff. We also put out a variety of mass mailers. So there's something we call a newsnet. This is just our newsletter, essentially. The Copyright Office is a couple hundred years old, so we have newsletters that have now become news nets since the 90s, and we just keep that kind of old-fashioned name. So you can sign up for those. You can get them on the events, you get them on policy, you could get them on everything. And that's where you're going to find out if there's a change to the registration system like we're developing now, like Chris mentioned. That's where you're going to find out if there's a webinar that's a really good fit for you, or if we're going to be in your town. But it's just how you stay up to date. And of course, if social media is something that you do, you can follow us on X or LinkedIn or YouTube, where we post a bunch of those videos. We don't have a slide for this, but I'd be remiss if I didn't mention something that just launched recently, is a copyright registration toolkit, which is a really visual way to understand all of this information and how to get through the registration process. So that's available on the front page of copyright.gov, and we'd love to hear your feedback about that because we just launched that about a week and a half ago. I'll transition into just something nice to close with here, and then we'll take some questions. Every year, the copyright community, which includes all of you, but of course it includes the government in terms of the Copyright Office, the U.S. Patent and Trademark Office, and our counterparts in other countries through the World Intellectual Property Organization. We celebrate what intellectual property means. And for us, that means what copyright means. And this year, the theme was music, which is very exciting because often the theme is something like green technology, which is important, but not as exciting for all of you and for all of us. So I just want to invite you to follow along with us. April 26th of every year is World IP Day. So we're just past that date now, but there's still just kind of a celebration going on as we have multiple events. We engage members of Congress who are oversight committees, people who are in corporate communities, both in the core copyright industry, which makes up such a big part of our GDP, but also those who just appreciate music or who consume all of the creative works that we put out. It's a time where people can every year find a place for themselves in the IP system, in the copyright system, and understand that everybody is both a creator and also a user. They are creating their own works all day long. That can be your music, it could be photographs you've taken today or notes that you've written, but you're also using other people's works, and understanding that respect, that give and take is an important way of how this country works. It's about ideas that can only come from you, like your head and your heart and your soul, and what they can mean to you as a person, to your community, to your nation, and just in general, according to the Constitution, to the progress of science and the useful arts. So I'll leave it there. We'll stop sharing, and we're happy to take questions that you have. And thank you.
Yeah, I've got one. The small, what I call small claims court, I guess, is what you talked about. Something under $30,000. What sort of claims? Do you know what sort of claims have come through that process? What sort of situations or scenarios are
Sure.
typical or
I'd be
unusual?
happy to take that. Yeah, sure. So first, TCB is at tcb.gov, or it's just through the Copyright Office website. And the docket is actually public. So I'll talk a little bit about it, but you can go in there and read about any of those things. All those filings are public, so you can see who's suing who, what happened with it, what the final decision was, all those things. Um, ab about most of the filings have been in the visual arts area, but the next step is sort of a combination of music and film. The film being largely shorter form films like YouTube videos, things like that. But there's been a little bit of music in there. A lot of the claims or issues are around copyright infringement, which is one of the 3 types of claims you can file. So it's somebody saying, this is someone using my work without permission, and I'd like to be compensated for that. I would like them to acknowledge that it's mine, stop doing it. The other 2 forms of claims are, I'm doing something and I believe that it's okay to do. So a declaration of non-infringement, asking the CCB or the board to agree with you that this is fair use, or that it's otherwise okay, which is a normal function of a court. It's also an option at the CCB. And then the misrepresentation claims are less frequent. It's a very technical area under the DMCA, which is around notice and takedown. If you're maybe on an internet site like a YouTube, or maybe a retailer site like an Amazon or an Etsy, and somebody's using your work without your permission, the website has a safe harbor that protects them as long as they give you a way to report that. So to put it simply, if there are issues with that process, there's a way for certain parts of that to go through the CCB. It's a little bit less frequent. I think what we're seeing there is it's a technical area, and sometimes people hear misrepresentation and they think that it's broader than it is, like a general fraud kind of claim. And that's not what the CCB is for. You can take general fraud claims to your small claims court in your municipal, like in your city. So yeah, I mean, most of them I think are more in the copyright infringement area, things like photographs that are being used, or like music that's being used without permission.
Well, when you say without permission, would that be a situation where somebody is written a song and maybe performed that song, and I don't know whether they may or may not have copyrighted through the Copyright Office, but somebody else has taken that song and has done a recording of it and is making money off of it? Is that the situation we're talking about without permission?
Yes, that's exactly right. Or they could be taking a recording of a song and using it, syncing it and using it behind, a short film, or using it on a website, or using it in some other way. So you have a bundle of rights in your copyright. And so if anyone's using any part of that, it can be an infringement. So at the end of the day, when you see your work out in the wild and someone else is using it without your permission, in general, it's smart to look into what your rights can be. Like I said before, if you're coming to the Copyright Claims Board, you don't have to have registered your work at the Copyright Office beforehand, but when you get there, they will ask you to. And that can be accelerated because both the things are within the Copyright Office. But we need to know that you have the rights, right? And then you can enforce the rights. In federal court, you have to have done that beforehand, which can lead to a chilling effect. So you go to a lawyer, you say, someone's taken this thing that belongs to me, and they'll say, well, where's your registration with the Copyright Office? And you'll say, I don't have one of those. And they'll say, there's not really a lot I can do here. It's not really going to go anywhere, which is why this exists. So this allows people in that situation to come and say, well, I'm going to register it now, and then I'm going to try to enforce it here.
Well, what happens if somebody takes a song and he's aware that it hasn't been copyrighted through the Copyright Office, and that person sends in a copyright? What what about, can they do that? Can they get away with that?
So
Or-
when you are filing a registration with the Copyright Office, you are making an attestation that what's in your application is true. And Trey, do you want to say a couple words about this?
Sure. I was just going to say, we have situations that we refer to as adverse claims where both people could claim ownership in the same work, and as an office of record, in certain situations, there are obviously caveats, but in those situations, we will put both claims on file. And if there's a problem with them, then the courts can decide. We are an office of public record, so we create public records. And then, if you don't know this, when you complete a copyright application, you are providing a certification that the information that you're providing is factual. To the best of your knowledge, and that is what we do, as an office of public record.
Mhm.
Right. So if you get into it with someone in that situation, that we can get into joint authorship, and there's all kinds of ways where you're working with other people to create things that it can get complicated. But in a simple case where you just disagree on who owns something, and maybe someone's swooping in to steal something that's really never theirs in the first place, yeah, that's for the courts. That's outside of us.
Yeah.
You would have to go to court. They would ask a lot of questions, and then there is a part of the law that allows the court to ask us if we had known those additional facts, would we have registered it in the first place? And it's kind of a complicated legal process, but it does exist in the law for sure.
Do
Well,
you have a pre-screening process just to catch obvious things? Like if I were to claim toccata and fugue in E minor, and it's simply a transposition of Bach's work, would you catch that, or would that have to?
Can I take that one?
Sure.
For works that are primarily like very famous, like a piece of that nature, we are very fortunate that would be something that would come into the performing arts division, the division that I work in. We are very fortunate to have staff of so many different backgrounds and so many levels and different areas of expertise. And so, there are people who specialize and are well versed in classical. There are people that are well versed in pop music. There are people that are well versed in hip hop, rock and roll. And so, if you're submitting sort of a transposition of a well-known work, that does not, we would not put that on.
So there is a
on record.
little bit of diligence there to, kind of catch the obvious.
That's right. And remember what I said about original works of authorship. You can't just regurgitate a work that's already
Right.
existed and then change the key. I mean,
So you do a cursory check anyway.
That's right. We'll do a cursory search. There's so many different ways that, where works can sort of live nowadays, with so many different types of content creators and, people composing and creating stuff for, the various social media, platforms. But yeah, we'll do a cursory search for the particular work, and we, as a part of the examining process, we really look in depth into the work to determine its copyrightability.
And I'll just add that I'm at the Copyright Office now. I've previously at the U.S. Patent and Trademark Office in Policy and International Affairs. And one of the differences between the way the Copyright Office works and the way that the Patent and Trademark Office works, even though everyone has examiners, is that the examination process depends on the law and the legal requirements in the law. In patent law, the patent examiners are looking to see if it is new, if it's novel, if it's non-obvious, if it has utility. They have to look at prior art. They have to look at what came before, because they need to say that this is a scientific discovery. This is something new that nothing came before it that's like that. So the search process and the examination process, according to the law, is very different because the law is very different. In the trademark area, they're looking to see who got there first with this brand because the brand identifies the source. So if somebody already has Coca-Cola for some kind of carbonated beverage, they probably got there first with that class of goods. And that's a process that happens through examination and through correspondence with the applicant. On the copyright side, like Trey was saying, two people can independently create something that's very similar, and that's fine under the law. We can't look back and say, well, Romeo and Juliet exists, so I guess we're not going to have a West Side Story. They're awfully similar. You know, that's just not the way that it works. But we are looking at the requirements of the law, and we're, like I said, one of the only countries that does that examination process. In most countries, when you create something, you just own it, and you don't really know until you go to court and fight it out with the lawyers and the lots of money if there's any there. So this is just the way that the U.S. system works, and Trey is correct that we're fortunate to have a great crew of examiners and a great crew of leadership over those examiners that applies the Constitution, the Title 17 of the Copyright Act, all our regulations that applies those things, and then something called the Compendium of Copyright Practices. This is a guide that's available on our website that you can really dive into if you just have a spare afternoon and just really want to get into it with a tasty beverage. How examiners think, how we're instructing them to consistently make decisions that are fair, how we interpret things, and how it works. So we really invite you to check that out.
Well, that works if a work being copied is well known, or it's out there. But what about a situation where you've got somebody that's written a song that the music the music is unique, or the words are unique, but nobody knows has ever heard it besides the guy who wrote it and maybe his friends, but he copyrights it. How do you check with somebody else that might take that work and copy the music or copy the words and put different music to it? How would you know if that's copyrightable? I mean, you can't go around and check everything, can you?
Well, I want to distinguish, I'll give it to you, Trey, in just a second, but I want to distinguish between two concepts. First concept is copyrightability. The second concept is infringement. These are separate. Copyrightability is something that the law controls and that the Copyright Office provides a record of. You already own this thing to the extent that it's possible to own it under the law. We're examining it, we're verifying that, we're putting it in the public record so people know. Infringement is not something that we do. We don't enforce for infringement. So these are private rights. So what'll happen in the real life world is the person who wrote the music, the person who wrote the lyrics, created the song, put it out there, hears this competing piece of music and says, hold on a second, that sounds an awful lot like my song, or it seems like my recording. And that is within their right to explore that enforcement. And what you would do is you would take, as the owner of the original work, you take your copyright registration, you come and bring it to court or to the CCB, and you say, I filed this, you gave me a registration, there's a presumption under the law that these are the facts and that they are correct. And that gives you an advantage. It streamlines your way with the court. And the other party has to come in and say, oh, well, I have my own rights and this is what it is. And it's up to the judge to deal with that. So that's a legal enforcement process. That's a different process than the registration process.
You're going to go ahead and copyright both of them, and then they've got to fight it out later.
Mm-hmm.
So you're going to give a copyright no matter what, I guess, if they say it's my work, And
well, and remember, we're not granting any rights you don't already have, to the extent that you have them. And so if you try to claim more rights than you have, and then you get into court, you're going to be vulnerable because you will have tried to claim more lawn than is yours.
Right.
And so you'll be put back into what you actually own.
The copyright is going to protect you and give you some rights whether you copied somebody else or not. I mean, that might be proved that the second guy was the guy who gave the idea to the first guy who copyrighted first or something, who knows? But you're going to copyright them both and then let them fight it out later.
Well, I think it sort of kind of depends on like most of the applications that we get in from people. People are very the applications are structured in a way where the questions are very specific and they get to certain aspects of the work. And I mean, really not down into the nitty gritty, and so people will offer the information about their work. I mean, it behooves you to fill out a copyright application with as much accuracy and facts as you can because you essentially have to certify at the end of the application that everything that you've provided relative to the work is accurate and is factual to the best of your ability. Now, if that is not the case, well, I mean, we don't there's no way to police, whether or not it is the case all the time. But typically, when applicants fill out applications, they want to be as forthcoming as possible with the information and provide as much information about their work to protect their copyright interests as much as possible.
Is the application process well documented so that those of us that don't do this as a full-time thing can follow the process and do it right the first time? Because there's so much stuff out on the internet about poor man's copyright things that are obvious. Yeah.
Don't mail it to yourself. This is
Right.
No.
But yeah, is the process well documented enough that we could follow that without assistance?
It's well
is.
documented. Oh, sorry. I was just going to say
No,
there are
you go
helpful
ahead.
links. There's help text. There's all kind of resources available. There are hyperlinks that take you to different places that provide additional information. Let me tell you, it's user friendly, and if you follow the help text, you won't have any problem because
Excellent.
the people in that build the system, they are very conscious about people of varying levels of copyright knowledge. And so we do as much as possible to make sure people are equipped and can complete the applications to the best of their ability.
Yes, and you can call us. Like we were saying, you can call
Super.
PIO. They will do a walkthrough. Like Chris was saying at the beginning, we're dealing with, of course, you can file on paper. It's just cheaper to do it online 'cause it's cheaper for everyone all around. So that's why we suggest you do that. But we are working on the next generation of the current system. And so if you're working on the online system and you get frustrated with it, that's okay, because we have heard all of that and we are in the process of getting input from people like Chris to do our next iteration of that. And when that comes out, which it'll be a little while, but we're piloting things, we'll all do a lot of education about how exactly that system works. But it's going to take in all of these kinds of comments that we're getting. Yes, Chris.
Thank you.
Yes, I have a problem with a lot of these platforms like YouTube, Facebook, and all of them. Where does that come in with the CCB? Because I have a song a record that I did. I own part of the publishing with the original writer. Somebody sent me some money to send them the CD. I did. It went to South Dakota. Next thing you know, after 2 or 3 years, we found it's been 100,000 hits. YouTube won't talk to me. Nobody wants, and the kid who did it, he changed the cover and he's taken the song. We don't know and we've sent, ASCAP asked about it. We worked with ASCAP. They never got back with me. So what do we do now? Do I go to the CCB then to stir the pie?
You certainly can. I can't be your lawyer, but I can tell you that what you need, I have to say that, but one of the things that you should do is just know that when you go to court, whether it's the CCB or it's federal court, they're going to ask you for your application, for your registration.
Right. Yeah.
So you got to go get that. Of course, we have it. Trey mentioned, I'll just to put a quick plug in and then I'll continue with your question. But the copyright public record system is also a part of our enterprise copyright system, which is this next generation of doing business with the office. It is a much more intuitive, much easier to use way of searching those records. So you can go in there and search for yourself, your stuff. It's going to be filed according to how you put it in. So if you spelled your name wrong, That's how it is in there. But you should be able to get all of your stuff. You can always go through those processes to request various copies of registrations, and that's what you would be using when you go into any kind of litigation. It's tough, to monitor what
Well,
happens with your work when you put it out there. So I want to just acknowledge that as a working artist, it's enough work to just come up with new ideas and perform it and do the craft. And then on top of that, to run the business. And then on top of that, to do the enforcement. So we hear you, but yeah, you should definitely explore the
is
CCB
the
as an option.
mechanical rights group part of copyright? Is that an offshoot?
Mechanical Licensing Collective is something that we oversee under the Music Modernization Act. So it's not really a part of us, but under the MMA, we oversee them and we have an oversight role.
One other question. I put up a video on YouTube and I used, for what it's worth, I got the licensing, did all the work, but YouTube won't put it up. They're saying it's copyright infringement. And the biggest deal is because it's a political heavy duty little video about Ukraine. So that's what I'm saying. It's fine to work with you guys and everything, but it seems like the biggest problem is Facebook and these guys. First of all, you can't talk to anybody. Second of all, nobody answers you questions. It's like it's the machine kicking out and say, well, this is copyright infringement. They never did any background. So is there going to be something coming up to where somebody pulls these guys and ties them down a little bit or something? That seems to be the biggest headache of all, is collecting money and getting those guys. That's what the MLC is all about. I understand.
Well, I think to get to the sort of the center of your question around when you're uploading something to a platform, if you get if you're unable to meet the clearance requirements, and this would be the same as if somebody was a documentary filmmaker and they were submitting something to a film festival and it had clearance requirements.
Right.
If it's your work, if you're the author of the work, I mean, this is pretty straightforward. You're the owner. You have the records. You have the copyright registration to show that. Anytime it's more complicated than that, it's going to be more complicated than that. And since copyright is a bundle of rights, the license you have to get to sync it and put it on YouTube is different from the license that you need to perform it as a cover or something like that.
But you do.
And I'll also add that the platform, they have their own rules. And so they have their own sort of copyright team that monitors these works, and they'll provide you ample notice and information about what terms your work violated. So I would say start there.
Well, I did, and all I got was copyright infringement. They never pinpointed what it was, or whether it was the music or a picture I used, or or a segment or something. And you kind of
as a lawyer who has dealt with these things in the private sector, I would say probably talk to a lawyer in the private sector about those things. They're going to be able to kind of pick it apart, help you figure it out. So I'm sorry, I don't have a better answer for you. But we have a couple other questions, and then we're at 9:06. I don't want to hold you guys forever.
All right.
Oh, for us, it's 9 o'clock. So I don't want to stay forever, but let's take Beth's question, and then we have one more.
Yes, I had a question. Back in the 90s, I copyrighted some things in the old manual process. So a couple of things. I mean, the process is different, but I never did anything with the songs back in the 90s. Now I'm doing them for real, and I have no idea where any of my registration stuff is, or how to look it up, or anything like that.
Trey, you want to take that one?
Copyright.gov. We have an entire and if you go right to the website, you'll see search our records. You can search by your name, you can search by the name of the composition. It should be all right there, so I would just go there and see if that work is on record. If you've registered it and received a certificate of registration, then we have it on file. Just go to our records and you'll be able to locate it.
And if you can't, you can just call the office. We can walk you through how to do it. If you happen to be in DC, you could come in and you can do it in person if you want to. That's available too.
Thank you.
Of course.
So I have a question about a composition in public domain. You can copyright an arrangement and get half of a royalty from that? Is that, or half of the royalty? Is that correct, or is that a myth?
Oh wow, this is a layered kind of question. So works that are in the public domain, you can, if you submit an application for a claim in the arrangement, you can, as long as the arrangement meets our copyrightability standards, we will provide a registration in musical arrangement. Also considering that if the work is not in the public domain, that it's properly excluded or limited, what we say. So you would have to exclude the original material and register. If there's significant original new material, we can extend registration to that. But generally, and I will also, you touched on musical arrangement. I want to sort of touch on that as it relates to, I think musicians, songwriters think musical arrangement is one thing, but in the Copyright Office, we have a more flushed out sort of definition of it, and it has to include a significant amount of harmonies and what we refer to as polyphony. It has to have an original aspect of it, of authorship to it, rather than just be like we said earlier, transposed or written for alto saxophone, right? There's certain sort of standards if you have a claim in musical arrangement. I won't go into the nitty gritty because it can get complicated, but there is a way to create a new version of something that is in the public domain and have it registered under your name.
And I'll
Yeah.
we'll move out of music for just a second just to illustrate the concept. But when we talk about that modicum of creativity under the law, what it goes back to is a case that's about telephone books. Telephone book takes a lot of work, takes a lot of sweat of the brow, which is the legal doctrine we're talking about. But it's not really original. Those are just facts. And if you add illustrations, if we're talking about the yellow pages, they've got pictures in them. If you're talking about the white pages, these are people's phone numbers. There's just nothing there. There's nothing to incentivize creative wise. You can use a contract to incentivize the work it takes to do that. That doesn't take a creative mind. So in copyright, what we're really looking for is it doesn't have to be a lot. And sometimes to artists that can be surprising, in that you can just add a little bit of something creative and sometimes that can be enough. But what you really own is just the little bit that you added. That's the case if you take a picture of yourself in front of the Mona Lisa, you're only going to own the small amount of originality in the picture of yourself. You don't own the Mona Lisa behind you. It's the same with artificial intelligence. You're not going to own what came in from the AI. You're just going to own what you did with Photoshop afterwards, maybe. It's the same as when you use someone else's work and you layer something on top of it, or you take a piece of public domain work and you layer something on top of it. It's that thing that you layer on top of it. That's what you own. That can be very thin, or it can be really substantive. Translations are sometimes similar. You don't own the underlying work. You own what you did. Like you own your creativity, your creative output, your creative work. And that's what we're looking to find. And that's what we look at an application for you to tell us.
Well, let me give you a good example of that. Jimi Hendrix performance of Woodstock of the Star Spangled Banner. You could copyright that.
Really?
Yeah.
Good. I haven't heard it, but I'm sure with Jimi Hendrix on it, there is some level of creativity and originality to it. And that sounds like that is probably copyrightable. Yeah.
I feel like I want to go check that out. That seems like a good
I
way
know.
to end up.
Oh, you kids.
I haven't heard that.
I
Sounds
know.
amazing.
Bless your hearts.
Yeah.
You've never heard it? Oh, Lord.
I know.
The
You guys, I gotta
recording
go.
is
I gotta go.
copyrightable.
I gotta go listen to this recording. Sounds
Yeah.
amazing.
Yeah. The recording, absolutely. Somebody made that point. The recording is absolutely copyrightable because
Yes.
it's Hendrix performing.
And his arrangement.
Yeah.
So Let me say one other thing. I'm fond of saying, if you want to learn how to write songs, take a song that you know and write new words to it, and then change the music, and you have a new song. Is that fair?
It depends, like any good lawyer would say, it depends. Copyright is not about bright lines. It's very case specific. And so that's why we have examiners. That's why we have lawyers. It's something where it's a broad enough doctrine to be flexible. And there's a lot of details in those areas like the compendium or the educational things, but it's always going to depend.
Well, throughout the music industry, it's always been you can use the first four bars of a song. Is that true, or is that just something?
This is not a part of the law. I have been in other creative industries where you say you got to change it 30%. That's how you know
Yeah.
it's not going to be infringing. There's no basis in the law for this. This is just sort of like a risk management, a comfort of risk analysis that might be norms inside of an industry. But
Oh, country music. Yeah. It's
if
like
somebody doesn't agree with that, they're going to hit you with a lawsuit immediately. And then you're going to have to figure out, are those first four bars so significant that they can really hold a copyright? And then there you are infringing.
Well, I was talking to my engineer and we were kind of thinking, what made the song copyright? If it's a country tune where you're doing G, C, D, just like every other song, but it's the words. And I tried to say, well, it's the words and how they pertain to the melody of the music.
It's if you keep this in mind for musicians, basic chord progressions are not copyrightable. Standard, run-of-the-mill progressions are not copyrightable. I think your point is accurate. It's everything and how you put it all together.
That's why all modern music is the same song.
We've all heard that
This has really moved, I think, into we're in the song, we're in the criticism part of this.
Yeah.
And I feel like
For
you guys
sure.
should get into your song criticism as a
for
group.
sure.
We do need to do that, but we certainly appreciate your time and your expertise.
Yes.
Yes,
Of
we
course.
really did.
Thank you so much.
Thank you.
Of course.
Very informative. Thank you.
Awesome program. Awesome.
It is an
program.
honor to be here. And honestly, I mean, Trey and I were just talking about this as you guys were just, shooting the breeze at the beginning. But this is an ideal way for us to start, to end our day, really, because we work for you and we want to know what you want to know. And this is what we do here. So thank you for the honor of spending the evening with you.
Well,
It makes us think
Thank
about
you.
things that we need to be thinking about more. I'm sure a lot of us, I don't need copyright that or whatever, but I think you do. So hopefully everybody will be more motivated to copyright their stuff.
Yeah,
It's indeed a pleasure. It was so much fun. I hope we provided some helpful information for
Well,
you.
I've got another
Excellent.
group called Folk Alliance, International Folk Alliance, and
I know the International Folk Alliance.
okay,
Yep.
they're in regions, and I want to bring you to the farm region and have this same deal. So
Great.
I'm going to promote. I'll get you guys out there then.
Send us a note. It'll come to me. We'll figure it out.
Okay. Thank you both.
Thank you so much.
Thank you.
Thank you,
I'd like
guys.
to add to it before
Thank you.
y'all leave. Before y'all leave.
appreciate
We've
it.
all heard that 4-bar rule and plagiarism, but more modern day definition of plagiarism that I've heard is if it's reminiscent of a published work. It doesn't mention the number of bars, just if it's reminiscent.
Well, that's a broad term too.
It depends. That infringement analysis is done at the point where you're in court, and there's factors under the law, and we could go on for another 3 hours about this. So I would just say there are no bright lines in copyright. It's a really difficult area of law, and I really applaud you for showing up to hear about it. So find yourself a copyright, as it were. Come visit us in DC if you're here. We'd love to have you. And please reach out absolutely anytime. And thank you all, and thank you, Chris, for the invitation.
Oh, thank you.
Thank you.
Thank you very much. That was great.
Bye.
Bye.